without further ado, I'm going to stop sharing my screen and Steve, you can take it away.
Thank you. Thank you. Welcome, everybody. So this has been quite a roller coaster the last few weeks. When we scheduled this Zoom call, I thought that I was going to be talking to you all about what do we do now that the courts are all open. And as many of you know, that entire plan got sidetracked on May 7th when the governor issued his eviction moratorium that basically put a stop to all evictions and all eviction notices until July 10th. Before that, we had a whole patchwork. Every county court, it seemed, had its own time frame. And so on the one hand, the governor's order at least made things easier for us in the sense that we didn't have to remember what county we're in and what the rules are. We just got kind of knocked on our head again this morning because I saw this morning that the governor issued another executive order yesterday. And in that executive order, and props go out to Leah Sailhammer from the Apartment Association, who had a lot of work involved with this. But the governor has now amended his eviction moratorium to say that it only applies in the case of non-payment or in the case of a holdover after the end of a term. So we are now back in a position where we are entitled to start the eviction process for people who have violated their leases in ways other than holdovers and non-payment. So in that regard, it kind of throws us back into a patchwork. So let me address the patchwork quickly because I think we're about a week or so away from there being almost no restrictions across the state for now lease default evictions, I'll call them. In general, the courts were instructed by the Supreme Court to open back up on May 4 and start doing business again, focusing on priority cases, which, as you might be able to guess, generally does not include landlord-tenant matters. But at least there was light at the end of the tunnel where we could start proceeding and we could file the complaints, and the courts would accept them, but might be slow in scheduling evictions. The latest date that I saw in any county court in Pennsylvania was May 29. So while the Supreme Court told all of the local courts to open up as of May 4, it also told them that if they currently had orders in place that extended beyond May 4, that they could continue to comply with those orders. So a handful of the county courts had May 29th as being the day that they would open up. A couple were June 4. So with regard to lease defaults, the county court calendars are now going to control. So I'll just throw out a couple of examples. Philadelphia County, for example, I think runs through June 4. Allegheny County, for example, runs through May 29. I'm not aware of any counties in the central Pennsylvania market that have any specific deadlines other than the May 4 that originally the court put in place. So in the central Pennsylvania counties in general, you should be able to start the eviction process for lease default cases. You just need to know what your county is, whether they have the orders in place or not. So with that caveat and with the governor's order yesterday kind of throwing that wrench in the works, let's go back to the initial governor's order. And actually, before I do that, I mentioned Philadelphia County is June 4. Actually, Philadelphia County just issued an order yesterday as well. And Philadelphia has now said that all writs of execution or all writs of possession in Philadelphia County are stayed until the governor lifts the statewide stay-at-home order that applies to Philly, or July 10, whichever comes latest. So Philadelphia County is still going to be under the governor's order with regard to lease default issues as well as non-payment and as well as holdover. So if you're in Philly, you're in essence still stuck to the governor's order regardless of the reason for the eviction. So going back to the governor's moratorium then, what really does that mean? When he announced this on May 6th, I think it was, when he had his press conference, He said he's putting a halt to all evictions through July 10. There's a 60-day moratorium. But what he also did, and what people sort of missed, was that he put a stay in place on any eviction notice that's required under either the Landlord Tenant Act or the Manufactured Home Community Rights Act. So really what he did in that executive order was extend evictions not through July 10, but in many cases for potentially 30 days beyond July 10. Because during the moratorium, you're not allowed to send eviction notices out. And if you try to send an eviction notice out during the moratorium, it's not effective until July 10. So it will be deemed to have been served on July 10. July 10 is when you start the clock, whether it's 10 days for non-payment of rent, if you're in the manufactured home community business as well, whether it's the 20 or the 30-day notice period. Doesn't even start until July 10. If notices had been sent out prior to May, and his executive order took effect on May 11. So if eviction orders had been sent out prior to May 11, then they are stayed as well, and they will be deemed to have been served, even though they've been served already. They will be deemed to have been served on July 10. So even for the notices that you've previously sent out, you can't start the clock until July 10. If there is a case that is pending, an eviction case that is pending in any court, so you have already given the notices that were required, and prior to May 11th, you filed your eviction complaint. And this may go all the way back to March, because if you remember, the original eviction stays that were put into place by courts began in about mid-March. So if you have a case where an eviction complaint has been filed and you've just been waiting and waiting and waiting, that is also stayed until July 10. So hearings on those pending cases will not be rescheduled until sometime after July 10. Now, you may get hearing notices in the meantime, but the hearings themselves will not take place until after July 10. So notices to quit can't be served during this moratorium period. Default notices are different. And I have to talk about default notices in really two different scenarios. One is in what I call the apartment community industry, as opposed to the manufactured home community. In the apartment industry, default notices that simply tell the resident that they're in default and they owe a late fee, for example, are okay. You can continue to send those, no problem. Notices to quit can't be sent. A default notice that says your lease is terminated, you must vacate, cannot be sent. Those notices will not be effective until July 10. In the manufactured home community world, because I know some of you manage those as well, the typical default notices that we send have the 20-day period in them. And so those can't be sent because they will be violating the governor's order. What you can send in the manufactured home community world is simply a default notice, because late fees are still collectible even under the governor's moratorium. So if you're in that world and you want to send default notices out to let residents know that they're in default, you can do that, but they can't be the typical notices that we would send under the Manufactured Home Community Rights Act. So that's kind of the lay of the land right now under the governor's order, and then under the new Philadelphia order from yesterday, and then the governor's new order from yesterday as well. You're going to fall into one of those camps, and whichever camp you fall into is going to control how you proceed in any given case. What I want to also mention just briefly is the HEROES Act that's currently pending in the United States House of Representatives. Nobody that follows politics on either side of the aisle believes that the HEROES Act has any chance of passage. It covers everything from PPP loans to eviction moratoriums to foreclosure moratoriums to a moratorium on debt collection activities. It's just a humongous bill that has a lot of different stuff in it, and nobody believes it's going to pass. As a matter of fact, the Senate has basically said it's DOA when it gets into our chamber. But there are a lot of bits and pieces of it that could be pulled out into smaller bills, and the fear is that some of these smaller pieces that impact our industry may in fact get some traction. So as it relates to eviction moratoriums, you're already aware, I presume, of the eviction moratorium that was put in place by the CARES Act that Trump signed back in March or May, I think it was. That moratorium does not impact anybody who does not have tenants who are on Section 8 or other voucher programs, or who do not have federally guaranteed mortgages. So if you're what I call a standard market property, the CARES Act does not impact you in any way. The HEROES Act, however, if it were to pass in its current form, or if the eviction moratorium language would be pulled out and processed individually, it would expand the CARES Act moratorium to every single landlord, not just the ones who get dollars. So under the CARES Act, the moratorium goes through the end of July, and it prohibits eviction notices from being sent before July 27, and then prevents evictions until August 27. So the CARES Act moratorium is even longer than what Governor Wolf's moratorium is. So if it were to be extended to all landlords, then it would in essence put us all in the same boat, where now we're restricted until the end of July and the end of August. The problem with the HEROES Act is even more, because if it passes in the form that it's currently in, it would extend that moratorium for 12 months. And that's 12 months from the CARES Act enactment, which was, it was mid-May, I believe, mid to late May. So we're talking about potentially having a moratorium imposed on this industry by the federal government through May of 2021. In my mind, that would be completely destructive. And I don't know how you all feel. I can't see faces. I imagine a lot of people are shaking their heads or scratching their heads. But if that were to pass, that's the world that we're going to be living in through May 21st. What that means is, and again, if the language in the HEROES Act passes as is, it also means that you cannot send late notices, you cannot send default notices, and you can't charge late fees. So it would really put this industry on its head if it passes. My suggestion on the HEROES Act is to pay very close attention, watch what's coming out of the National Apartment Association, watch what's coming out of the Pennsylvania Apartment Association, keep an eye on that. And when you see calls to action being pushed out by the associations, make sure you're contacting your congressmen and your senators and voicing your opposition to this. Because if we sit back and we're silent, this is going to end up getting passed underneath our noses, just like the CARES Act did. As a matter of fact, when the CARES Act was first being discussed, there weren't too many in this industry that were even aware that it involved eviction moratoriums. It was a small section in the middle of what was an extremely large bill. So we're now all on notice. The HEROES Act should be on our radar, and we should be watching for that. So having laid the groundwork and kind of the environment that we're all in, that's about all I wanted to say. So I'll open it up to questions. And if you want to talk about something other than these moratorium, I'm certainly happy to discuss other stuff as well. Back to you, ladies.
Right, and with that, we will go ahead.
If you want to type in your Q&A questions, we can read them for you at the bottom of your screen, so everyone's not talking on top.
And if you're trying to talk, just keep in mind you're muted, so we're not hearing you. No questions. Wow.
I don't know, can you hear me?
Yeah.
Yep.
Okay, cool. So if I'm understanding this right, a resident or a situation where there was a balance prior to COVID, and like COVID really just didn't impact this person at all because they weren't paying anything anyway, I will be allowed presumably to start the filing process again in July. Is there a chance outside of the HEROES Act that the governor can still just increase that moratorium locally?
Could. He would not do it. When you say locally, he would not do it, for example, I don't suspect, for certain portions of the state, although he could. There was some talk this morning on the news about he may be announcing some more counties going yellow next week. may even be announcing some green counties. So it's possible that he could modify his moratorium either to remove it completely in the counties that are green, for example, or he could extend it, for additional time periods. I think a lot really is going to depend on where the state is on the color map as we get closer to July 10. And it's going to depend a lot on whether the COVID numbers start increasing now that people are out and about a bit more. But yes, under the state of emergency that's been declared, he would have the power to extend it even further if he believed that was appropriate.
Steve, we have another question that came in.
Sure.
What is the status for evictions that were scheduled but canceled due to courts closing? The constable was supposed to remove the resident on 3/23.
So if you're in Philadelphia County, ain't happening till at least July 10. And even further beyond that, if the stay-at-home order in Philadelphia County has not been lifted by then. If you're in any other county in Pennsylvania and it relates to rent payments, then you're stuck until July 10 under the governor's current order. So if it's an eviction complaint that was filed for a lease default, for example, then under the governor's amended order yesterday, that should be able to move forward now. And it's just a matter of reaching out to your MDJ or the constable and saying, understand that we can now schedule this and take your lead from them. I imagine there might be a little bit of a delay until the courts kind of get their hands around this, but if a lease default other than non-payment, they should be able to start moving forward unless the county you're in has a different order. Like, for example, I mentioned Allegheny County, that nothing's going to move until May 29th, but that's only a few days away. So generally speaking, unless you're in Philadelphia County, you should be able to move those forward now as long as it doesn't involve rent.
And I think the question was they're in Delaware County, so they didn't know.
Delaware County, I'm not aware of any specific order in Delaware County. I'm not saying there isn't one. I'm just not aware of what it means.
We have another one. And it is they non-renewed a resident in April and their lease ends June 30th. However, they believe that she will not move out. What recourse do they have? They are also in Delaware County.
So at that point, again, subject to any specific Delaware County order that I'm not aware of, that's going to fall into the governor's moratorium as amended yesterday. It would still bar you from doing anything until July 10. On July 10, if you don't have a waiver of the notice to quit in your lease, you'll have to serve a notice to waiver at that point, or a notice to quit at that point. If you have a waiver in your lease, then as of July 10, you should be able to make the filing.
We have another question about is NAA. Are you aware of, Steve, that they're working on anything on stopping or the bad language in the HEROES Act?
They are. There was a legislative committee meeting earlier in the week, and they've got between NAA and the Multinational Housing Association, or NMHC. I can never remember what it stands for. Between the two of them, yes, they've got a team of. I think there were at least 8 or 9 people on the call that were talking about various parts of the HEROES Act. So they are actively trying to work through that. And make sure that if anything does get passed, it gets passed with consideration of our industry. Yeah.
Alrighty. Another one is, can we send manager non-renewals before July 10th?
So here's the deal. The governor's order specifically says that you cannot. That any notice that is mandated by the Landlord-Tenant Act or the Manufactured Home Community Rights Act is stayed through July 10. So if it's simply a non-renewal notice, then I think you're fine. But if it includes the notice to quit language, then it would not be okay because that's a mandated notice under the statutes. If you're in the manufactured home community world, well, you can't do a non-renewal anyway in that world, so that wouldn't be relevant. But yeah, I would say the kinds of notices that you can be sending are non-renewal notices that will not be effective until July 10, of course. Late notices, default notices. What you can't send is a notice to quit or an eviction notice. That's what's stayed under the act.
And I think we have one more question, and this will probably be our final one, which is, in Philadelphia, I have a court-agreed payment plan made in January and February that residents have defaulted, but have asked me to change the agreements. Is that okay to do?
You could change the agreement, but it may impact whether the court would then enforce the agreement if the payments are not made. So, for example, and again, in Philadelphia County, you're not going to get an enforcement of that agreement until, at least insofar as you're trying to get possession, you're not going to have an enforcement ability until after at least July 10 in Philadelphia County. But if what you did with the resident was modify the agreement to make it more beneficial to the resident, and the agreement is not complied with, then I think the court would probably still enforce it. But if you make it more onerous on the resident, like you're accelerating the payments or making them pay more per month, I don't know that the court would enforce that. If you're going to do a modification with the resident, I'd be very, very careful about the language, because what you want to do is you want to make sure that under any circumstances, you're preserving your right to go back into court and enforce that order. So you need to have language that preserves that right, that the tenant agrees that this modification is only effective so long as the modification is complied with. And if it's not complied with, then we're automatically going back to the court-ordered payments, and a default will result in enforcement. So okay to do, but it's not without the possibility of impacting your enforcement ability.
Alrighty, thank you. I think that concludes. Thank you, Steve. Thank you, everybody.
Absolutely. Absolutely. Everybody have a great weekend. Enjoy the holiday weekend. Stay well. And we'll catch up at some point down the road.
Thanks so much,
Thank
Steve.
you.